Good morning, Your Honors. May it please the Court. Vincent DeMoore on behalf of the Commonwealth. We're here today on this case asking that this Court vacate the lower court's ruling dismissing the complaint against the defendant. This case is very different, of course, than the other ones and presents fundamentally two issues. The first is whether or not it's appropriate to dismiss a case for the failure to provide exculpatory evidence which does not presently exist but may at some point during the course of an investigation exist. And secondly, whether or not it is appropriate to dismiss a case because of what was described as either the strong assumption or the possibility that Ms. Dugan may have been able to tamper with the defendant's sample. Or, if I can put it another way, whether or not the motion judge's proposition that something is true because it is yet to be proven false is an appropriate grounds on which to dismiss a complaint.
I had the sense in reading this that perhaps there was a problem he was perceiving with the ability for the Commonwealth to produce the information that the defendant needed in order to be able to proceed with the case, that the drugs were not available.
No, there were no issues with that. The drugs had been analyzed and were certainly available at that point. What occurred here is that the motion that was filed asked that the court dismiss the case because the drugs were at the Hinton laboratory, essentially, that there was this possibility that Ms. Dugan may have been able to tamper with them, although counsel acknowledged that there is absolutely no evidence whatsoever of tampering, and there's been no way he could make any kind of a showing with regard to that.
I thought the case was somehow on hold and that was concerning the judge, that there was...
Well, so what ultimately occurred was the judge didn't really allow the motion on those grounds, but found that essentially the investigations that were ongoing with the Attorney General's office, and this was prior to the Inspector General launching their investigation, but that essentially the discovery wasn't forthcoming quickly enough with regard to the investigation, and that because of that, essentially the government was unwilling or unable to produce exculpatory evidence, and as a result, the case was then dismissed.
Had the defendant been held for like 14 months or something? Was this the case?
The defendant was, yes, correct. The defendant had been in custody for 14 months.
Was there any suggestion that rather than dismissal, the judge just admit the defendant to bail?
That was certainly one of the options available to the court, which would have been a far less restrictive sanction if sanctions are appropriate at all. However, at the time, the defendant was still held on a $25,000 cash bail out of the Superior Court on a case on which he had been indicted.
Another case.
Another case. So a personal actually would have been a detriment to the defendant because he no longer would have received credits on this case.
So I missed it, and you said it.
Sure.
It was on hold. Why?
Well,
It was $25,000 bail.
No, I know why he was held. Why the case
was on hold.
Yes.
And so the defendant had done a motion to dismiss, which was heard and denied. He had done a motion to suppress, which was heard and denied. And all of that wrapped up, so to speak, in early August of 2012. When the lab was closed on August 30th of 2012, what happened on a practical level is virtually all narcotics cases ground to a halt.
Yeah. So the discovery came, it was just in that period. It was delayed because of that halt.
Ostensibly, the defendant essentially was not ready for trial, so to speak, because they didn't have the information. I think we would have had a low comfort level moving forward on a trial until we were able to provide more information. But like many cases, this was one of the cases that was tested at the Hinton Laboratory by chemists other than Annie Dugan, where essentially the cases went into a holding pattern for a 3 or 4 month time period.
Now, is there a speedy trial analog here? I mean, as best as I can tell, the judge essentially is saying this case is being held for a long time because no one can be ready for trial until this investigation is over. Mm-hmm. And it's essentially a speedy trial concern that why don't we just basically dismiss the case? When that's all straightened out, you can recharge him and then we'll try it. Why is that, and why is that not sort of a sensible thing to do?
Well, there was never a motion that cited those grounds. Those grounds were never articulated by the court below. So I think it's...
Well, he was speaking about the view of how long it's going to take to get this discovery together and that it's the government's fault that this delay, which nobody wants to go to trial until this is sorted out, and it's the government's fault that it's a mess, and therefore the delay essentially is attributed to the government. I know he didn't use the language of speedy trial,
yes. But
that sort of, isn't that sort of the gist?
I think that was the spirit, so to speak, right, of where the court was coming from in terms of the court's concerns as it articulated it at the hearing.
I thought there was, well... thought it was more critical of the government than just speedy trial.
Yes, but I think with respect to Justice Kant's point, that the government wasn't moving quickly enough in bringing exculpatory evidence to the defendant, therefore, this is going to take too long, so I'm going to dismiss this case now, and you can feel free to recharge him later. I think that's essentially what it came down to. But there's some fundamental problems with regard to what the judge did with regard to that. There was a lot of exculpatory evidence that was produced to this point to the defendant. By this juncture, he'd already received all of the state police reports. He had received, the day of the hearing, in fact, he'd received an additional 450 or 500 pages of discovery, which constituted the Department of Public Health's internal investigation report. So there's this presumption that existed in the court's mind that there was, in fact, exculpatory evidence to turn over that had yet to be turned over. And in essence, the dismissal of the case was rested on a presumption that there would be further exculpatory evidence in the future, and that this would go on essentially in perpetuity, and that the case could just never be tried. And if we accept that proposition, I'm not sure where we draw the line with regard to that, because it essentially says that the defendant can always speculate that sometime in the future there may be additional exculpatory evidence on any given type of case.
Is there an ongoing investigation right now?
There's the Inspector General's investigation, the Attorney General's investigation with regard to the indictments that were brought closed. The indictments came down, I think, in January of 2013, so actually shortly after this hearing. In terms of the...
But the internal investigation and the state police investigations have concluded?
Correct. And to the best of my knowledge. Of course, I'm not sure. I haven't asked that question point blank, but to the best of my knowledge, that's the case. And certainly in terms of the discovery as a practical matter, that we've been provided following essentially the disclosure that occurred on the day of the hearing in this case. There was the disclosure of the emails that followed, and following that, it's been quality control documents, lots of graphs and charts, things that were sort of internal laboratory records. No investigative reports, no state police reports, no statements of witnesses, for the most part. But fundamentally, the judge's decision here was rested on that premise that something may at some point in the future exist, and because something may at some point in the future exist, you're unable to provide it. It was really penalizing the government for not providing information which it neither had nor could even say existed in the first place at all. And certainly at a minimum, a more appropriate remedy for the court to have done here was to order an evidentiary hearing to find out exactly what has been turned over, to find out exactly where the status is with regard to what the investigation is, to dismiss the complaint, which is...
Or as you say, put on bail, or
reduce the
release
bail
in
to person.
personal, yeah.
Yes. I mean, there were, or provide the defendant greater latitude with regard to cross-examination, should the case ultimately proceed to trial. There were a number of options before the court that were far less restrictive than the dismissal of the complaint, which dismissal without prejudice, short of the dismissal with prejudice, is really the most extreme sanction that the court could impose. So with regard to the court's actual findings itself, many of those findings I'd also suggest were really unsupported by the record, or there's no evidence to suggest that they must be true, that they are true. The notion that it would take counsel months to review all of the discovery. There's no there's no information in the record whatsoever that that's true, besides the gross number of pages involved. And also this finding that we were unwilling to provide exculpatory information. I think the record, the history of this case, in which we did provide a great deal of exculpatory information, and our behavior in all of these cases has suggested that the moment it comes into our possession, it gets turned around and disseminated to defense counsel as quickly as possible.
Right, but there is some part of it which is, it seems true, which is that the IG has been delegated the task of doing the comprehensive investigation, and that report is not out yet. And this dismissal occurred when?
This was in December, I believe, of 2012.
So right now, we expect that the judge, if he arguably could have said, the IG report is not going to be out for a year, and we can't really try this case until we get the IG's report back. And would that not be a sensible thing with regard to speedy trial, to say that the delay essentially is attributed to the government, and that's analogous to a speedy trial problem?
I don't think so. And as a factual matter, I'd have to double check the dates on all of this, but I believe that this dismissal was ordered prior to the Inspector General being tasked with doing this assignment at all. But let's presume for the moment that that's not the case, and the IG had already begun their work with regard to this. To hold that against the Commonwealth as opposed to the government writ large would essentially be to allow other independent constitutional agencies within the government to bind the Commonwealth's hands with regard to when they can prosecute cases or the timing on which a case is prosecuted. It wasn't the district attorney's request that the Inspector General engage in their investigation. That was a task which they undertook as part of their separate independent constitutional function at the request of the governor. So the fact that this report, which presently does not exist but will exist in the future, to suggest that that is what's delaying the prosecution of the defendant's case it's just not exactly right here. The defendant may want that information, and the defendant should certainly feel free to wait for that information, so to speak, by filing motions for that information. But in the same way that we exclude time in a speedy trial motion, that time is really, frankly, it's excludable because that's the defendant requesting information or seeking information.
But what's different here, maybe, and I'm thinking out loud, is the defense asked for that, but the reason for the delay is because we need to investigate government misconduct. Not merely we're awaiting a report for what may be exculpatory information. Mm-hmm. We're awaiting an investigation of government misconduct. And one can say, well, then that delay is attributed to the government because it's the government misconduct that's under investigation.
But it's the production of the report that is what's delaying it, as opposed to the conduct itself, which is under investigation. So it's the issue isn't what's the nature of the misconduct involved. The issue is, does this information exist at all? And fundamentally, this case was dismissed on a theory that this information exists. And I think it was described as an assumption or maybe a strong assumption. It was modified, I think, in the judge's findings. And the presumption, the innuendo, sorry, that was the phrase, the innuendo. But I'm not exactly sure. I wasn't entirely clear on what that meant. But what I do know is that there was no facts to support that this information exists at all. So to dismiss
This information being what? I mean,
I don't know.
There wouldn't have been an investigation for no reason.
I take
It's about the conditions in the lab.
Yes, and I think my answer in short is I don't know. I don't know what information we're talking about here, because we're talking about theoretical, hypothetical information that may someday be committed to paper.
It may be relevant or may not be
May
relevant.
not be.
And we don't know.
I have no idea. Nor did the judge, nor did the prosecutor at the time, nor did counsel for the defendant. It's this possibility that this information may someday exist, and it may be a strong possibility. We may assume that this report may come out. I have no idea. It's also possible, although I doubt it very much, the Inspector General may issue a report and say the lab was a wonderful facility and every lab should be just like it. As unlikely as that may be, that's a possibility too.
Okay. But would it matter? I mean, I know here she had some role in looking at what appears to be marijuana, and that's not even charged here. Mm-hmm. Would it be a different case if she were the primary chemist as to the drug charged? In terms of the speedy trial issue?
With respect to that, in terms of the speedy trial issue, no, because it doesn't change the fact that there's the information that's being sought, so to speak, may or may not exist. So it still would be, it would still be attributable to the defendant, so to speak, in the speedy trial context, if we're looking at it from that frame.
Well, I take it if she had been one of the chemists on the case.
We would have ordered retesting.
Right, you would have
Yes.
ordered retesting, and you'd have another set of evidentiary issues to deal with.
Yes, which I'm sure this court will see in 6 to 9 months. But if the court has no further questions with respect to this, I think the bottom line with this case is it was dismissed based on, quote, innuendo. I don't know if the exculpatory evidence would have ultimately been available or existed in the first place. Neither did the court. And to dismiss a case based on that strong assumption or strong presumption, I'd suggest is a far too extreme sanction. So unless the court has any questions,
I just have one. She was the notary public in this case?
She was.
Is there anything in the state police reports that suggests that she had handled any evidence other than evidence for which she was either the primary or secondary chemist?
Only cases for which she was the, as I read them, the primary chemist, in fact. Secondary chemist, the evidence that she would handle would be the vial that would be passed off to her, but the actual evidence itself as primary. There's no allegation that the notarization was improper, and frankly, the notarization is not relevant anyways, after Melendez-Diaz.
Wasn't the notary on the,
Yeah, well-
on the drugs here. She was the notary on some marijuana
Yeah.
Yes.
case,
The
not this
co-defendant was
case.
arrested, right? Isn't it that?
I'm not sure exactly in terms of that. I'd have to double check. But even if she was, let's presume hypothetically she was the notary public on the cocaine or whatever it was. It doesn't matter. The notarization does nothing for its admissibility anymore. That ship sailed in 2009. So it really makes no difference. Thank you very much.
Thank you, counsel.
Morning, Your Honors. Rebecca Jacobstein for Reginald Gardner. The court properly exercised its discretion to dismiss this case, and the reason is because the Commonwealth should not be allowed to proceed with potentially tainted evidence.
Well, what's tainted here?
I think her misconduct in this case, we're discussing it as if we can trust her. We're discussing it as if she said that she was tampering only with this part of the evidence, and that, well, that's proof that that's all it is. But it's not. She's committed perjury. You know, she's charged with perjury. She's charged with tampering with evidence. She's lied to police officers to the investigators until confronted with very specific evidence. We have no reason to trust that it's limited to what she says it's limited to.
So your theory is, as long as she was in the building, anything that happened in that building could be tainted?
As long as she was
no matter
in
who
the-
tested it, no matter what other chain of custody there might be?
If she was in the lab, yes, because to relate the misconduct to this case, so we know that she's falsified test results, and the judge in this case said, well, she still had the keys. The judge said she still had the ability to tamper, that she was, and there was an indication that she had maybe tampered with evidence of one of the chemists in this case, and the Commonwealth didn't dispute this fact. But in the larger scheme of things, there were no safeguards in this place. So there was no oversight. And anytime they found problems, because problems were noted along the way, they ignored them, they swept them under the rug. So everything was accessible to her. And she had the key to the evidence safe. She had the access to the evidence database. She violated the protocols to do all of these things. She went into the safe with impunity. She went into the database. And then there's the problem that she maintained the equipment. At least there's some indication that she may be the person who maintained the equipment. And she falsified the data about her maintenance. She forged people's signatures with respect to the tune reports. And this is an easily contaminated piece of equipment, and it seems that through the evidence that there are a lot of ways in which things can be easily contaminated, and further discovery shows that this place was a disaster. You know, there was unsecured drugs in unknown locations everywhere. And so to say that, well, she didn't touch it, I think minimizes the ability for things to go wrong throughout this laboratory with respect to her individually, and then with respect to other people who were there. And then one thing that my opponent discussed is that, he did turn over a good deal of evidence. But that's not really the point, because they didn't turn over all of the evidence. And I would submit that all of this evidence existed at the time. It may not have been marshaled.
What didn't they turn over?
One key piece of evidence for Mr. Gardner's case that they did not turn over, they had yet to turn over, and they have since turned over, was an email from Annie Dukin to a prosecutor stating that she had access to anything and everything in November of 2011 when Mr. Gardner's drugs were in the facility. And so that's a big piece of evidence for Mr. Gardner, that she still, even though she was supposed to be off the line at that point.
But wasn't that, if not in her own words, that was at least obvious from the state police reports?
Well,
I mean, she was in the building. She still had the key. She was doing desk duty.
Yeah, but I think what it goes to is it shows how she felt that she could just do whatever she wanted. And that she could go in and she could just say, hey, I've got access to that. And, you know, her falsifications weren't limited to just, you know, the aliquots. She falsified weights. And so we don't know, how did she do that? Did she just lie? Or did she move drugs from one place to another? We don't know. We don't know what she was up to. And the fact that there were absolutely no safeguards is a problem. And I think, and then, you know, everything that they had about what was in there, the documentary evidence, all of that stuff goes to Mr. Gardner's case, even though she is not on the certificate.
If we were to assume all that you say is true, why is not the more appropriate remedy simply to release and recognizance?
For Mr. Gardner, it wouldn't have been, because at 14 months, I don't know exactly what the recognizance conditions are, but it's still not nothing. And at this point, he's been in for 14 months. You know, at this point, he's got this choice. I can have a speedy trial, or I can have a fair trial at some point in time in the future, which is just going to have to be delayed. And that's not fair, even if you're out, especially after 14 months. I mean,
I thought he was being held on a high bail on another case.
he was held on bail on both.
Slow bail on this case, high bail on another.
I don't think he could have made bail. I think bail on this case,
2,500 or something?
I don't think he could make. I didn't get the impression.
He wouldn't have been out.
It wouldn't
He
have been.
would not have been out. He is out now.
You know, assuming we agree with you, doesn't it follow that every case, whether she was the notary, whether she was involved as the primary or the secondary, because she had the access, because of her history and because of everything that you listed, every case could potentially be affected?
Yes, it could.
And therefore, we should dismiss every case that came through the system in order to avoid the possibility that she had contaminated it, manipulated it, done what you just listed for us? Doesn't that follow?
It does. It does in some regards. And with respect to Mr. Gardner, though, he's pre-trial. And so, you know, the Commonwealth admitted that there is no proof. They can't know. They don't know now, and they may never know whether or not she tampered with these drugs. And I think at this point, the
Well,
Commonwealth,
because you say everything was accessible to her.
everything was.
Yeah, because you say, we know that she tampered with evidence, she falsified weights, all of the things you listed. Why wouldn't we take it to the point then to say, well, if that's the case, then every case that came in the pipeline should be dismissed?
Every case all the way back, or every case
Yeah.
just during?
Yeah,
From 2003 to 2011.
I don't think every defendant would want necessarily their case dismissed, so I don't think it would be appropriate.
Why?
Why wouldn't, well, there are reasons that you might not want your case dismissed and have to go through a trial again. You know, especially ones that are as old as 2003, 2004. But I agree with you. I agree that it's tremendously awful, but so was her conduct, and so was the lax supervision over what she did. You know, people are being held, and people have been held based on, you know, her word, and her word is nothing. And not only that, it adversely impacted other people at the lab, and it adversely impacted everybody whose drugs went through there. And it may seem, I guess, unfair to the Commonwealth, but it's more unfair to the people who don't know what's going on when she's there and she's messing with the whole system. And I also wanted to point out that other states that have addressed this type of issue have found per se due process violations. So they haven't actually required a specific showing that the chemist involved, or in one case it was a serologist.
Yes, but take the serologist. That's the West Virginia case you're talking
Yes.
As I read it, what the court came up with after its own investigation was that it would be, that the government could still prove those cases if, I mean, what was necessary was to show that the serologist had some connection to the individual's case.
Yes, and they said that they could retry the case if, without that
But
evidence.
you could apply for habeas corpus, but it wasn't clear to me, I didn't think, that you were going to get out unless you could show that he had something to do with your case.
Well, see, yeah, thank you for bringing that up, because I wanted to bring that up, which is there's a difference between that man who only touched his cases and this woman who touched everything. Her hands were everywhere. They were in all the cookie jars. They were in the setup cookie jars. They were in the evidence room cookie jars. They were in the database cookie jars. She was everywhere, and she was so sloppy that even where she wasn't potentially purposely doing things wrong, there's I guess there's a lot of protocols around to avoid cross-contamination because it's not difficult for that to occur.
And how do we as a court make that finding? Based on what evidence?
Well, there was testimony that's in the record appendix that the machines were easily cross-contaminated, and there was also, I believe, evidence in there that files were left open and protocols were not followed, and that was the general gist of that.
Testimony in what proceeding? This proceeding?
Oh, no. This proceeding, the evidence was, of course, very limited.
Okay, so which proceeding are you referring to? The testimony that you say comes from where?
In the record appendix, I believe it was the grand jury in her cases.
So we're supposed to make findings based on what is in a grand jury transcript when she has not been tried?
With respect to, I'm sorry, I'm not following.
Well, we're supposed to rely upon the grand jury transcript as evidence that we can rely upon in making a factual finding as to the status of her involvement in the lab when she is still awaiting trial?
Well,
Isn't there a problem there?
Well, no, we're not asking the court to agree to the veracity of anything in the Hinton record appendix. We're just saying that it's there, and it demonstrates all of these things, and the fact that it was, a lot of it was delayed, the disclosure was delayed, and then some of it was not included, meant Mr. Gardner, until the whole thing's resolved, can't go forward. And so it wasn't an abuse of discretion to dismiss it at that point, because his trial was going to be delayed indefinitely, and the misconduct was on the Commonwealth. I did also address in my brief the request that this court exercise its superintendent's powers for all defendants in Mr. Gardner's situation, which is pending cases where where Annie Dukin was in the laboratory but no longer taking tests. And based on all the reasons that I just discussed previously about the information provided, I think that again demonstrates that in no case should the Commonwealth be able to proceed, able to rely on potentially tainted evidence. And I remember the Commonwealth being concerned about where do we draw the line. Well, there could always be potential evidence coming down the line. I think that this case calls for line drawing. We've got a government actor where there's an ongoing investigation, and as Justice Lang said, we don't have ongoing investigations for no reason. And then the government's doing the investigation. So we've got defense has no access. The defense can't go out and do this investigation itself. This is something the government has to do. And I think that that's where you draw the line. If a government actor is, and they're relying on this evidence, it's necessary. If the government is relying on evidence provided by a government actor under investigation, that should be suppressed until all the information's out there. So unless there are any further questions, I rest on my brief.
Thank you.
Thank you.
Thank you.